Ready, start. Where a transfer is sought, making allegation regarding integrity or influence, etc., in respect of the presiding officer of the court, this court has to be very careful before passing any order of transfer. Stop para. In the matters where reckless false allegations are attempted to be made to seek some favorable order either in a transfer application or otherwise, the approach of the court must be strict and cautious to find out whether the allegations are bona fide and if treated to be true on their face in the entirety of circumstances can be believed to be correct by any person of ordinary prudence in those circumstances. Stop. If the allegations are apparently false, strict approach is the call of the day so as to maintain not only discipline in the courts of law but also to protect judicial officers and maintain their self esteem, confidence, and above all the majesty of institution of justice. Stop para. If there is a deliberate attempt to scandalize a judicial officer of subordinate court, it is bound to shake confidence of the litigating public in the system and has to be tackled strictly. Stop. The damage is caused not only to reputation of the concerned judge but also to the fair name of judiciary. Stop. Veiled threats, abrasive behavior, use of disrespectful language, and at times blatant condemnatory attacks like the present one are often designedly employed with a view to tame a judge into submission to secure a desired order. Stop. The foundation of our system is based on the independence and impartiality of the men having responsibility to impart justice, that is judicial officers. If their confidence, impartiality, and reputation is shaken, it is bound to affect the very independence of judiciary. Stop. Any person, if allowed to make disparaging and derogatory remarks against a judicial officer with impunity is bound to result in breaking down the majesty of justice. Stop. Although the aforesaid judgment was in terms of section 24 of the Code of Civil Procedure 1908, but the principles pertaining to transfer of case would be squarely applicable to the present case as well. Stop para. Upon applicability of the aforesaid judgments, it is evident from the perusal of the impugned order that the transfer of appeal has been allowed by means of the impugned order in completely casual and routine manner without any application of mind to the objections raised by the petitioner. Stop. As has been dealt herein above, such an order allowing the transfer application in a routine manner cannot be condoned. Stop. It is also seen from the record that as persons have been cast against the integrity and character of the presiding officer hearing the appeal. Stop. However, the same has not been substantiated by the transfer applicant oblique opposite party number 4 in any manner. Stop. Allowing the transfer application merely on such averments is being forwarded upon. Stop. The impugned order does not even indicate that the averments made in the transfer application have been prima facie proved by the transfer application. Stop para. In view of the aforesaid judgments, it is quite clear that the impugned order is clearly unsustainable and therefore a writ in the nature of certiorari is issued quashing the impugned order dated 18th February 2020 passed in transfer application.